For judgment. Item 1.
It's partly allowed.
Item 2.
Partly.
Item 3.
It is criminal appeal is allowed.
Item 4.
It's partly allowed.
Item 5.
Partly.
Item 6. Item 7.
With certain operation, we appeal this disposal.
Item 8.
Partly allowed.
Item 9.
Criminal appeal is allowed.
Item 10.
Allowed.
11.
It's partly allowed.
Item 12.
Partly allowed.
13.
If some modification is partly allowed.
14.
It's partly allowed.
15.
Partly allowed. Yes.
Any mention?
See, till 2 o'clock, I'll take off all these matter. After 2 o'clock, 91, 92 matters I'll take. Because we can't afford to leave those matters. You read it. If nobody is there, we will start reading it. We'll appoint someone and finish it up. Okay? Okay.
Pardon to make a mention. My
Yes.
My lord, item 60 can taken up at 2 p.m. my lord.
60.
Item 60.
No, 2007. Wait. If time permits, then I'll take it. Huh?
Lords.
Okay. Yes.
Item number 32, my lord. On behalf of Mr. R.C. Behera, she is out of station next week, my lord.
Let it be there, madam. 2007. Let it be there. I'm not passing any order. Huh? Let it be there. Next week I'll take 2 hours. Yes. I may not get that kind of time today. Yes. Any mentioning? Okay.
Item 16.
Yes.
In item 16, your lordship,
Hmm.
the law and counsel for the appellant on their day already argued that's his side, your lordship, her
Hmm.
side. So for my responsible submission, lordship, on the last date of hearing, your lordship directed to certain points regarding whether section 50 has been, of the NDPS Act had complied or not.
Hmm.
My respectful submission, lordship, here is prosecution in order to bring home the charges against the present appellant accused, 8 witnesses examined. Out of 8 witnesses, your lordship, there is the 6 witnesses are the government officials and 2 witnesses are the independent witnesses, lordship. Out of 6 government witnesses, PW1 and PW8, PW1 is the ASI who is on the very fateful day was on the duty, the patrolling duty. When from which circumstances the contraband article has been seized, that to be ascertained in order to bring home the charges section 50 of the NDPS Act, your lordship. That is my submission. At that effect, I will submit the evidence of the PW1 and PW8.
What do you want to say? I read it.
Your lordship, my respect submission, lordship. The contraband article was seized from the bag. Section 50, so far 50, you need to bring home this protection under section 50, your lordship. The clearly says the person, if the search made in the person, but here is the contaminant article is seized from the bag, which was in hand, your lordship. My response to that effect, section 50, protection under section 50 is not at all attracted in this present case and situation, your lordship.
Your Lordship, that is why I've given a judgment where it is said that even if there is a bag but even if it is established that a bag is being searched, but if in-person search is also conducted, then 50 will be attracted.
Yes.
But my learned friend is though is, I have relied.
Relied upon some judgment.
Yes, Your
My-
Lordship,
my-
that is the specific judgment.
That is which judgment? That judgment is, I think, Vikram Singh. Which one? You have given some judgment. Which one, Vikram Singh?
Your Lordship, 57 OCR and 47 OCR, Your Lordship.
No, you have relied upon the first judgment.
Yes, Your Lordship.
That is,
State of Haryana versus Vikram
Yes.
Singh. That would
which
be-
paragraph you are relying?
नहीं, सब बुरा नहीं था, मत देखिए.
Your Lordship, 57 OCR, the placetum itself says, Your Lordship.
57 OCR.
Yes, Your Lordship.
57 OCR is,
2014, 57 OCR SC 1087, Your Lordship.
that is Parmanand.
Yes, Your Lordship. State of Rajasthan versus Parmanand, Your Lordship.
State of Rajasthan versus Parmanand. That judgment you have not given, it seems.
Your Lordship, I've-
Yes.
Yes, Your Lordship.
No, you-
Your Lordship, if merely a bag carried by a person is searched,
Where are you reading?
Your Lordship, the placetum itself.
Yes.
Itself, if merely a bag carried by a person is searched without there being any search of his person, Section 50 of NDPS Act will have no application. I agree to that, Your Lordship. However, if the bag carried by him is searched and his person is also searched, Section 50 of the Act will have application.
Relevant paragraph you read.
Yes, Your Lordship. Your Lordship, relevant para is para 12, Your Lordship.
Para 12.
Yes, yes.
Yes. Thus,
Huh.
merely a
The
bag carried by a
Bag carried by a person is searched without there being any search of his person. Section 50 of the NDPS Act
Will have no
have
application.
no application. But if
bag carried by him
he
is
is searched and his person is also searched, Section 50 of the Act will have application. In this case, respondent number 1, Parmanand's bag was searched. From the bag, opium was recovered. His personal search was also carried out. Personal search of respondent number 2, Suraj Mal, was also conducted. Therefore, in light of the judgments of this court mentioned in the preceding paragraph, Section 50 of the NDPS Act will have application, Your Lordship. I would have had no case, Your Lordship, if my bag is only search and that is it, Your Lordship. But why I'm saying that the trial court has erred that Section 50 is not applicable, because after searching my bag, they opted to search me also, Your Lordship.
Therefore, 50.
Therefore, I'm
Yes.
saying that Section 50 is attracted.
Yes.
My
next point.
response, I have relied is judgment Ranjan Kumar Chauha versus State of Himachal Pradesh.
Huh.
In that case, your lordship, the similar identical to the case your lordship present appellant appeals.
So
The-
me,
Your lordship.
Your Lordship,
judgment,
Your Lordship, that
Supreme
judgment.
Court judgment.
Yes, Your
Yes, yes,
Lordship.
Lordship.
Your Lordship, that judgment also have gone through. Your Lordship may look into para 120 of that.
I know the judgment, Your Lordship, State of Kerala versus Prabhu and Your Lordship, that is identical, Your Lordship.
Give that.
In each case, and
Kerala is the
Yes.
recent one.
yes, sir.
Show me which para?
Lordship, that paragraph, Your Lordship. I'm not-
Assistance means you have to show me the paragraph. I
Yes,
can't
Lordship,
read
that,
the entire judgment.
Absolutely correct, Your Lordship, but I have not this clear copy, Your Lordship, I could not do.
What kind of,
Yes,
see the process.
Yes, I
You
am.
want, you give all bench of judgment, I'll keep on reading.
No, no, sir, I'm not.
I have to write judgments also.
Your Lordship, you apologize.
You show me which paragraph. You can't throw the judgment on my face
Lordship.
and say that read it.
No, no, no. The Kerala judgment is very.
Tell me which part, then I'll have to read the entire judgment. It takes its own time, you know. I don't have that kind of, see, we expect at least effective assistance from the prosecution. I told you, otherwise if people will not give, then I'll write your concession and acquit everybody. Because these are the matters pending since 90s and you don't assist at all. And you expect me to read everything. Para 7. It says that it is held that if the recovery was not from the person and where the bag was carried by him, the procedure of the formality prescribed under section 50 of NDPS Act was not required to be complied.
That is what we are
Good.
saying.
And it is to be noted that the case on hand, also the evidence are disputedly established that the recovery of the contraband was from the bag and which was being carried up by the respondent. Therefore, section 50 is not required. That is the law.
No, Your
Now,
Lordship.
this-
Yes, Your Lordship.
This is now in 2024, a contrary view is
Your
taken.
Lordship, no, 2025 judgment which my learned senior has given Ranjan Kumar Chadha, that is a Supreme Court judgment. Your Lordship,
No,
we look,
that's 23 judgment.
that's a Supreme Court
20, I
judgment.
am reading 25.
Yes, Your Lordship, that 25 judgment also
What
says
is the
that
exception? Para 120.
para 120
Let us see
says
what-
in Ranjan Kumar
What
Chadha,
does it say?
in the facts of the present case, there is no scope.
Para 20.
Para
120.
120.
Similarly, a recent judgment of this court.
No, Your Lordship, Ranjan Kumar Chadha is para 120, if I'm reading.
120, I am reading. ACC online.
No, Your Lordship, in Singh citation I have.
Insane. Starts with what?
Starts with the word in the facts of the present case. The facts are similar.
1 minute. Well settled. Analysis.
Towards the end, Your Lordship, towards the fag end.
In the facts of the present case, that's
Yes, sir.
127.
There is,
Right.
yes, Your Lordship, there
There
is
is no
no
scope.
scope of applying the ratio of Parmanand and SK Raju. At the cost of repetition, we may state that in the case on hand, there is nothing to indicate that the search of the person of the accused was also undertaken along with the bag, which he was carrying on his shoulder. Your Lordship may note this.
Let us see PW1.
Yes, Your Lordship.
Let us see PW1.
Yes, Your Lordship.
What does it?
PW1 is, Your Lordship, the informant.
1 minute. PW1.
Yes, sir.
Yes. What does it say?
I know the accused in the dock, so and so.
No, read the relevant part.
The relevant part is 7 lines from the top, Your Lordship. The accused was holding a foam bag in his hand.
The accused was holding a
Foam bag in hand. On opening this, I found 2 bottles of ID liquor and ganja in a packet were kept in that bag. On being questioned, the accused gave his identity as Vijay Kumar Sahu of village Sanpur under Bolagad PS. Then I demanded any authority for transportation of liquor and ganja, but the accused could not prepare the same. He stops there, Your Lordship. Then Your Lordship may come to PW.
No, thereafter what did he, this is what he, PW, who is the IO?
US PW 8, Your
No,
Lordship.
no, come to para 4 of the same witness.
Of the same para 4 again, Your Lordship.
On the arrival of IAC,
IAC,
so
CP,
he went to search
accused.
the
He went to
accused.
search the
He told
accused,
me
Your Lordship.
that he
And
gave
before
an
doing,
offer.
he gave an offer to the accused that he has right to be searched either before a magistrate or before a gazetted officer. But the accused told that he can give search before the police, and before him he is a gazetted, and also before
Nothing in writing is given.
No.
Let us see, IO. Come to IO.
IO is PW 8, Your Lordship. May directly look into paragraph 3, Your Lordship.
Para 3.
Yes, Your Lordship.
I
He came to Nayagarh bus stand along with Bipidas IAC Nayagarh PS. I found the accused in dock was standing in the bus stand with a bag, and he was detained by ASI Mahanti along with APR force. I examined PW1 at the spot. I asked the accused his name and identity, to which he has stated that he is Vijay Kumar Sahu, such and such. Then I expressed my intention of search of the bag and person. Your Lordship may note this. Bag and person.
some contraband.
As suspected that some
search
contraband in that
bag and person.
Yes, Your Lord.
Both.
That is what is my contention.
Yes.
I also gave him offer whether he is intended to be searched before a magistrate or a gazetted officer. So what I'm contending is that, Your Lordship, there was an in-person search also carried out.
He
besides the
expressed his
bag.
willingness to search for the so-and-so gazetted officer.
Then the
I-
IAC Nayagarh Pipidas gave him his identity to the accused, stating that he is the inspector of police and gazetted officer. Accused has stated that he has no objection if he will be searched before the IAC.
Hey, nothing is given in writing.
No,
It's oral offer.
Nothing. That is not there, Your Lordship. That ground we have taken in the trial, before the trial court also. Before effecting search, I gave my personal search to the accused in the presence of witness, Your Lordship. So our contention is, when you are searching a person in person, along with the bag, section 50 has to be carried out. And he has not recorded any reasons as to why mandates of section 50 were not given in writing or any such thing. As the last time my learned opposing counsel had said, Your Lordship, that 55 mandates that without writing even they can proceed. But in order to comply, that also they need to give the reason that why they could not give it in writing, or what was the emergency that they could not give it in writing.
Yes. What else?
The consistent statement of the Schedule 1 and 8 that the contraband article was seized.
But
from-
now it is that the person and bag was searched together. That's the evidence of PW8. He searched the person as well as bag,
Also.
which is being carried. And the exception carved out in the judgment of Ranjan Chopra is, if it is together, he is carrying it. Then if the bag is searched along with the person,
50
section
is
50 is to be complied.
mandatory.
When that point goes, even the
Kerala-
facts of Kerala judgment is bit different. Bag was not carried by him; it was kept somewhere else. So therefore, there are two distinct search. Bag search is one, and person search is one. So therefore, the court says section 50 is not required. If it is together, he is holding in the shoulder,
Then
carrying it. And this is because of the reason that the quantity is very small. So he was holding it, carrying in his shoulder. So therefore the bag as well as the person is simultaneously searched. Therefore section 50 is required to be complied. This is the position. Next point.
Sure, one more point is that pertaining to section.
Let him, I have heard you. Yes.
if my esteemed sister's contention is taken to be that there is both the accused persons and the contraband bag is seized from the bag, then section 50 is mandatory also. Here is the case, the IIC is the gazetted officer, and after obtaining willingness
That
from-
same gazetted officer was not examined by you.
But yes, exactly.
And
that-
two witnesses you have examined.
not been examined.
Two witnesses, one examined, that witness is also turned outside.
that is
Then what?
Independent
section,
witness not sub-
in which angle you will say that section 50 is complied? Which angle? And surprisingly, the IIC, the gazetted officer is supposed to be called. Surprisingly, the IIC himself comes to the spot. Says that I am gazetted officer, I'll do it. This is section 50.
Your Lordship had,
These are the procedural safeguard to be very strictly and scrupulously followed.
followed, so doing it followed.
earlier queried.
And that's the reason I have serious doubt from the evidence that the IIC was not there. It was only the story made out. Therefore, the IIC was withheld from bringing to the witness box. Gated officer was not followed. Therefore, the story is made out. The IIC came, he was a gated officer. All the story is made out. Well, it can be seen from
Yes,
the
sir.
record.
That is on record.
दे दो
I will keep the written.
दर यस अभी दे देना मैं भूल जाऊँ बाद में दे देना चलो नेक्स्ट
Item 17.
यस मैडम
No, my lord.
what is that you are there madam
20.
no 17 pass out 18
18.
yes sir pass out okay 19
19.
19, Your Lordship. 19. I am appearing on behalf of Mr. Dhananjay Mund, who is the learned counsel for the petitioner. May I submit, Your Lordship?
yes
My Lordship, the appellant
what is the offense
was convicted with a misdemeanor under section 323 and 506.
hmm.
As per the
Sentence?
noting,
sentence what is the sentence
sentence is 6 months and 3 months rigorous imprisonment for 323.
323 and 506 huh?
My Lords,
6 months and 3 months
my Lords. My Lords, the paper book is, as per the noting, the paper book is not prepared.
in this court no paper book only pen drive
Maybe kindly soft copy.
you don't go to the primitive stage now much has changed now
My Lords.
everything is there read it and argue we don't have that much time you are a young man you can read it what is the problem take in the pen drive and get ready
My Lords.
ठीक है take
Well.
in pen drive get ready pass over करो
My Lords, kindly make it next date, my Lords.
it will be there in the list you get ready I will not take it up today but maybe day after
My Lord, one more humble submission. My Lord, the status of the appellant is also, we are unaware of
what
it.
is the age of the appellant
19. Since 48 minutes.
It's already 16
Maybe
years, my Lord.
presume that he is surviving they will pay you your fee get ready yes
Obliged, Your Lordship.
Item 20.
20
My lord, punishment was only under section 323 IPC, and appellant number 1 was sentenced to ₹1,000 only in default SI for 1 month. And
and there are two appellants
yes, my lord.
okay the
Appellant number 2 was sentenced to 3 months and ₹1,000 fine in default SI for 1 month. Appellant number 1 was in custody, arrested on 24/6/2008 and granted bail on 26 for 2 days remained in custody. And appellant number 2 was arrested on 24/6 and released on 2/5/2008.
will you argue on merit or I'll
Well, period under
period undergone or PO
PO.
so PO करो PO करो दे thank you madam give your name
Yes, ma'am.
give your name and yes yes
21.
pass out 22
22.
these are 2010 matters it can be
Please, madam.
22 yes
The
appellant has been convicted under section 354 IPC.
Yes.
Well, kindly have to the judgment part, my lord.
Hmm.
While accused on this 376 and 366 A IPC,
Okay, the charge under
stand
363
on 363, 366 A,
A and 376.
376. But the prosecution has to fail to prove para 10 under section 376, 366 A, but convicted under section 363 IPC,
Only 363.
only 63. And the
I hold that
You do-
not guilty under section 363 capitalization and acquitted under so and so. I hold the accused guilty of offense under section 363. And sentence is,
SI
Say it again, SI
3
for
months
3 months.
but he might have undergone some.
My lord, I may pardon, he has undergone, he was arrested on 3/11/2010, 11/2010,
3/11/2010, huh?
and released on bail 6/12/2010.
6/12/2010.
10. 1 month, 3 days.
1 month,
3 days.
3 days.
My lord, were released on a PO Act.
1 month, 3 days. What is the total sentence awarded?
3 months SI.
363. Then?
This is
What is the
kidnapping.
what is the prescribed 363?
Criminal administration is not in 7 years until the issue of the-
Whoever kidnaps any person from India or from the lawful guardian shall be punished with imprisonment of either discretionary period of time which may extend to 7 years. And shall also be liable to be fined. There is no fine also imposed.
Yeah, boss. And another thing, if my lord see the evidence of the PDL 4, is the
Thank
he
you.
is the victim.
We arrive for SI for 3 months and also fine is 1,000, your lordship.
Fine 1,000.
1 month undergone. 1 month, 3
2
days
days,
undergone.
2 days, 3 days as undergone. But
Okay.
there is an also fine
No,
for
3 months.
1,000, your lordship.
My lord, Mary, I pray religion pure. The evidence is not trustworthy, and her husband is a police constable. The investigation is done by the investigation, and
The judgment is also very sketchy. 3 pages, 4 pages judgment. Nothing is there.
yes.
What
Sorry.
kind of judgment is this?
On merit also,
Incident is of 2009.
2009.
Boy was 22 years. What is the story, by the way, in the case of prosecution?
Story, ma'am, kindly have a glance to the evidence of PDL 4, my lord.
The victim, while
I know the accused, I know the informant, victim is my man.
PW4. huh?
PDL 4.
Okay. PW4. Let us see. You see the victim, huh?
Hmm.
PW4. Victim. Okay. Yes.
The informant is my mother, and my lord has gotten.
Yes. yes.
The informant is my mother. I know the accused. Occurrence took place on 30th January 2009 at about 5 to 6 p.m. while I was residing in my maternal uncle's house and went to the canal. At that time, I was reading in class 10 in Bhajatola High School. The accused came, caught hold of me, and threatened not to assault. His brother Sushil Tudu was present along with the accused. The accused Dibu Todi and his brother Sushil Tudu took me by the muscle to village Kundilia to the house of Jenamaji. On 2nd of the next month, police went there and brought me. Accused was insisting for marrying me. I was examined with him. It is a fact that I have not stated before them. What he has stated here, 160 contradiction is there. It is a fact that I have not stated before the IO that the accused Dibu Todi caught hold of me and told not to serve. It is not a fact that I have not stated to the IO that the brother of the accused was also present along with a marshal and Sushil, the brother of the accused, and accused Dibu took me away to by the marshal. The accused has not raped me. When I went to the canal, no one also.
There is no sexual intercourse.
No sexual. So that's why he was acquitted in 376. Only not. So I release on pure. Acute. The killer case of acute. Also.
Doctors examined.
Malon,
PW9 evidence.
PW4
medical evidence
is
also.
the victim. Medical who is
We don't know.
we don't know. What does he say? There is no bodily injury.
Bodily injury.
Nothing is there. And this boy is young, they, I
At the
think
time of
he
occurrence.
looks and all.
Obliged.
Thank you. Yes.
23.
May it please, Your Lordship. It is a Gosala matter, Your Lordship.
Oh, that Gosala matter again.
Your Lordship, they filed Vakalatnama in 1620/2025.
You filed the vocal, no?
Yes.
But my lord, the order dated 11/11/2025 passed in 4435 of 2025 order not complied, Your Lordship.
Sorry.
Order
Second
passed,
matter.
second matter,
Second
Your
matter.
Lord. My lord.
In second matter, have you filed vocal now?
Yes, sir.
No, my lord, second matter, they are for the petitioner, but they
Acha,
have
acha,
not
nahi.
added me as
In-
opposite party.
Okay, in the first matter, have you filed?
First matter ମୁଁ ଓକିଲାତନାମା ଫାଇଲ କରିଛି ଏବଂ ଆଇଏ ଗୋଟେ ଫାଇଲ କରିଛି
IA for what?
appropriate order
IA for?
appropriate order
Huh?
appropriate order appropriate order
What I am proposing is,
yes
I will set aside the order and send it back to the trial court to, because see, the new report has come. That time the position was not clear. Whether what you call the cattle were, that was not clear. All these things were passed with a assumption that it was there with the Gosala, whatever. So what I am thinking is, let the trial court take a fresh look in the changing circumstances. All the report will be placed before the trial court. Let him take a fresh look. And thereafter you have a right to come here.
no question is your lordship is absolutely right I don't have any objections for the case if your lordship is remand to back to the trial court. Question is everything has been decided in accordance with it by the
No,
trial
but the facts were not clear. The cat, nobody knew where was the cattle.
then my lord all the evidence is in favor of my lord the petitioner because the warrant has already been issued against the Jimadars and the FIR has been registered.
All these things I'll
Charge has
keep,
been filed.
Mr. Maharaj, I'll keep everything open. You can re-agitate all these things.
But by
Let
the process,
let the trial,
only the lordship.
I'll give time bound. I'll give time bound direction. Let the trial court decide the application, your application, 457 application, which you have moved, on the basis of which this order was passed. Let the trial court pass a fresh order, taking into consideration the report and everything is on record here.
Yes, Your Lordship.
ଖାଲି ଗୋଟେ ଜିନିଷ ଖାଲି ରହୁଛି calculation ର
Hmm.
ବେସିକାଲି ତାଙ୍କର
Recalculated how କଣ ହେଲା?
କିଛି ଅସୁବିଧା ନାହିଁ ମୁଁ ସେଥିରେ କିଛି ନାହିଁ
ହଁ।
calculation ଟା ସୋ ମୋଟ ହେଇନି କି ଗୋଟେ presumption ରେ ବି ହେଇନି
Outre, let there be an application of mind, because see, so many things has come on record now. Everything needs to be
ଗୋଟାଏ ତ
considered.
ଗୋଟେ ଜିନିଷ ଆଜ୍ଞା ଆସିଛି
ହଁ।
ଅଲଗା କିଛି ବି ଆସିନି ସେ ପୋଲିସ କହିଲା କି କ୍ୟାଟେଲ କୁଆଡେ ଯାଇଛନ୍ତି ଆମେ କଥା ପାଉନୁ
ହୁଁ।
ଯୋଉମାନେ ଜିମାଦାର ନେଇଥିଲେ ସେମାନେ ଆମେ ଏଫଆଇଆର ଦେଇକି ଚାର୍ଜସିଟ କରିକି ୱାରେଣ୍ଟ ମଧ୍ୟ ଇସ୍ୟୁ କରି ଦେଇଛୁ
ବର୍ତ୍ତମାନ situation
ଇଏ ହେଲା-
different.
ଇଏ ଗୋଟେ କଥା sir। ଦ୍ୱିତୀୟ କଥା କଣ ନା ସେଠି ମଧ୍ୟ ସେମାନେ ଟ୍ରାଏ ଗୋଟେ ଆଫିଡେଭିଟ ଦେଲେ ଯେ ଆଜ୍ଞା ଏଇ ଷ୍ଟାଟସରେ ଆମେ ଅଛୁ କ୍ୟାଟେଲ କୁଆଡେ ଯାଇଛି ନା ଆମେ ପାଉନୁ ଯୋଉମାନେ କ୍ୟାଟେଲ ଜିମାଦାର ନେଇଥିଲେ ସେମାନେ ଆମେ ଚାର୍ଜସିଟ କରିଛୁ ଏବଂ ୱାରେଣ୍ଟ ମଧ୍ୟ କରିଛୁ
ହଁ।
ଥାର୍ଡ କ୍ୱେଶ୍ଚିନ୍ ଆସିଲା ଯେ ଏମାନେ ଯେତେବେଳେ ଇଣ୍ଟରଫିୟର କଲେ ସେ ପର୍ଯ୍ୟନ୍ତ କେହି ଇଣ୍ଟରଫିୟର କରିନଥିଲା ଯେତେବେଳେ ଏମାନେ ଇଣ୍ଟରଫିୟର କଲେ ଆଣ୍ଡ ୟୋର ଲର୍ଡସିପ ଡାଇରେକ୍ଟେଡ ଡିଏସପି କଜ ଆନ୍ ଇନକ୍ୱାରି ୱେର୍ ଇଜ ଦି କ୍ୟାଟେଲ ସେମାନେ ଆଉ କଣ କରିବେ ଆଜ୍ଞା ତାଙ୍କ ପାଖରେ ରାସ୍ତା କୋଉଠି ରହିବ କୋଉ ରାସ୍ତା ତାଙ୍କ ପାଖରେ ଅଛି ଯେ ସେମାନେ ଖସିକି ଯାଇପାରିବେ ଆପଣଙ୍କୁ ଅର୍ଡରକୁ ଫାଙ୍କି ଦେଇପାରିବେ
Therefore now they have ascertained the
ସୋ ସେ କଣ କଲେ ନା ଗୋସଳା ସହିତ ଟାଲି କରିକି ଯାହା ହଉ କହିଦେଲେ ଯେ ଗୋସଳା ନେଇଛି ସେ କ୍ୟାଟେଲ ସେ ତା ଦେହରେ ଗୋସଳା ବେଲେ କ୍ୟାଟେଲ ନେଇଛନ୍ତି ଠିକ ଅଛି ଯୋଉ କାଲକୁଲେସନ ଅଲରେଡି ହେଇଯାଇଛି କି ଏତିକି ଟଙ୍କା ଆମେ ଅଲରେଡି
that you will have to definitely tell that to the
ଆମେ
court.
2 ଲକ୍ଷ ଟଙ୍କା ଅଲରେଡି ଆପଣଙ୍କ ଡାଇରେକ୍ସନ
That will be taken into
My lord,
consideration.
Yes.
I'll say that. I'll
Yes.
say that. That will be taken
Yes.
into consideration. Not that.
state capital जो expect करछन्ती सेटा मध्ये your lordship.
Everything will keep.
Right.
I'll
Right.
pass a balance order so that it will not prejudice to EU or him.
Your lordship में previous record your lordship में mention the affidavit filed by the IAC, then this last affidavit filed by the SP. Everything your lordship.
I'll do it, don't worry.
Yes.
My lord, I have only objection, my lord. The amount stated by the learned counsel before this honorable court, that is disputed one, your lordship.
But I am not going to say anything on that.
Lordship, my lord.
Because I'm recalling that order, I'm sending
Yes,
it
my
back.
lord.
But the amount which he has paid has to be taken into consideration.
Taken into
The money
consideration.
has already been paid, wrong, right,
Right.
whatever.
My lord.
But that has to be taken care of.
lord.
Everything, I'll pass.
Instruction by थोड़े बेसी irritate होचंती. अगर जल्दी सदियों मत कहितले मत भारी बाती जे जे मु false कहूची.
Yes.
मु जो false कहूची बिली से दिन से मु कोठ आनिली. सेटा मु खाली आपण नॉलेज आपण ऑर्डर
No, my lord.
मु कोठ आनिली.
My lord,
देले 4 लक्ष.
When you are super excited in arguing a matter, you sometimes tell something.
किछि
And
अतिला नहीं.
particularly youngsters.
your lordship, particularly this honorable court, my lord.
किछि ना.
My lord, this honorable
Mr.
court.
Maharaja, youngsters can't resist the temptation of saying something. So
But-
let
but
them
then
say what
at
does
least-
it make difference.
At least it should be clear that I have not suppressed anything.
My lord, your lordship may kindly peruse.
फिक्स कला
It's all right.
सेटा तो मु प्रेयर कली सार से 4 लक्ष एति टका करछंती आपण जा कंसीडर करबे
It's all-
आपण 2 लक्ष ले व्हाट इज रॉन्ग इन इट
My lord, your lordship.
I am to say.
Your lordship.
See, if the wrong
repeatedly-
utterances made by a junior counsel, then the senior member of the bar is to be responsible. Not the junior, because they learn everything from the bar only. Give me.
Only submission, my lord. Your lordship repeatedly asked, what is the amount? What is the amount?
It's all
Even
right.
after
I'll
that,
take
my
care of.
That's why only, that is
I have-
my objection only, my lord.
ମତେ ଯୋଉଟା ତା
Fine, that's it.
ମୋ ତରଫରୁ କିଛି କହିବାର ନାହିଁ
How do I put the one? मुझे दियो, दे दियो. ठीक है.
My
Okay.
lord, the ratio decided by this honorable court is Dhyan Foundation.
Okay.
Grateful, your lordship.
Yes. 24.
I
Yes,
preach.
sir, what will happen to, see, nobody is appearing from Union of India. What is this? Do they know that this matter is pending here?
They may be in the virtual,
Let's see. Virtual.
virtually ordinarily they were there.
Tell me, solicitor, deputy solicitor.
In fact, I'll show your lordship, they don't have any role. Rather the role, I'm just showing your lordship, then again, just to recapitulate lordship memory.
Uh.
You also straight to come to page
But
50.
they are the main contesting respondent, it seems.
OP number 2 rather is the contesting. They have filed a count.
But who is appearing? The Union Council only is defending them.
No, sometime back, Mr.
What I'll do,
Patnaik, Mr. Patnaik was appearing. That he
you
there,
are appearing.
he is the contesting.
Then you are the real contestant.
Yes, yes.
Let us proceed then. Huh? Let's proceed. Yes.
You also kindly come to page 15.
50?
15, annexure 1.
Yes.
Sir, this is the act. This act, the Burma Oil Company acquisition of shares of Oil India Limited. I was in Oil India Limited. That's why kindly mark it. I was in, we were in Oil India Limited. And of the undertaking of India Assam Oil Company Limited and the Burma Oil Company India Trading Limited Act 1981.
So you have that, huh? Give. Understood.
Page 15. Annexure 1.
Yes.
This is the Act, 81 Act. And again, I'm reading the Burma Oil Company acquisition of shares of Oil India Limited and the undertaking. We were in Oil India Company, there was no dispute. Whether temporary or permanent, that's your choice. Of Assam Oil Company Limited and the Burma Oil Company India Trading Limited Act 1981, Act 41 of 81. Just I'm reading the preamble. An act to provide in the public interest for the acquisition of the shares of Oil India Limited held by the Burma Oil Company Limited and for the acquisition and transfer of the right title and interest of Assam Oil Company Limited. The Burma Oil Company Limited is a relation to the undertaking of India.
All are amalgamated.
Yes.
Yes.
Now you also kindly come to section 11.
11. eh?
Yes, sir. At page 21, chapter 5. The only relevant portion I'll show your lordship, then straight away I'll take your lordships to the
Hmm.
page 21,
Yes.
section 11, transfer of service of existing employees of the specified companies. What's it
You were existing,
Existing
employee of
in
Oil India.
Oil India. Then 2.
Hmm.
Sir, every whole-time officer or other employee of a specified company who was immediately before the appointed date, also mark it at page 15,
Hmm.
that is 28 September 1981, the day when this act came into force.
Hmm.
Am I clear with you?
Yes.
So every whole-time officer or other employee of a specified company who was immediately before the appointed day employed by that company in connection with undertaking in India, and every whole-time officer or other employee of a specified company who was immediately before the appointed date temporarily holding any assignment outside India shall on the appointed day become an officer or other employee. Let's skip over. I am concerned with every full-time officer or other employee of the specified company. Then kindly come to 2.
Hmm.
Subject to rules made in this behalf under section 22, every whole-time officer or other employees, let's mark it, of
Other.
Oil India who was immediately before the appointed date employed by it in India, and every whole-time officer or other employee of Oil India who was immediately before the appointed date temporarily holding any assignment outside India shall on and from the day continue to be an officer or other employee of Oil India on the same terms and conditions and with the same rights to pension, gratuity and other matters as are admissible to him immediately before that date, and shall continue to hold such office unless and until his employment under Oil India is duly terminated or until his remuneration and condition of service are duly altered by that company. Now kindly come to the next page, page 22, rule 12, yes, section 12.
Yes.
Section 12, we are concerned with section 12, subsection 3. Let's get it.
Yes.
The
Successor.
government company or Oil India, as the case may be, shall as soon as may be after the appointed date constitute in respect of monies and other assets which are transferred to and vested in it under this section, one or more trust having object as similar to the object of the existing trust as in the circumstances may be practicable. So, however, that the right and interest of the beneficiaries of the trust referred to in subsection 1 are not in any way prejudiced or diminished.
Yes.
Then, sir, kindly come to the rule. There is a rule I have enclosed it along with my memo. I have filed a memo along with that rule, that is 4/12/2023.
Yes.
Yes. Kindly come to rule 4. Let's get it.
Rule 4.
Yes. That is
That
relevant page.
Burma Oil India
This is
pension.
This is Burma Oil India Pension Fund. Let's
Yes.
get it.
Rule
That
4.
rule 4.
Yes.
4. Let's kindly come to 4.
Yes.
Except as herein before provided a former employees shall be entitled to a normal pension as hereinafter defines he has attained the pension age while still in service of the company and or is associated company. He has rendered 20 years of continuous service with the company and or its associate company. For employees transferred to India from service with the Burma Oil company, subsidiary company in Burma, the company in its sole discretion regard the period of those companies' absence from Burma as part of a period of continuation service for those employees who wanted for the order to evacuate from Burma in 1942. We are not concerned. And who were re-engaged on or before 30th September.
Were re-engaged on.
Yes. Then, sir, kindly come to next is 3. He shall have at the date of his retirement been a member mean a member of the Provident and Insurance Fund recognized the Burma Oil India Provident Fund or any other Provident Fund mentioned by the company or associate company and is a membership of such fund or funds have been continuous for not less than 10 years. And he has been in the receipt of salary or over rupees 200 per month at the date of his retirement from the service of the company or associated company by which he was at such date employed. An
Yes.
employee who qualified for a pension also skip over. Now, sir, then I'll come to that. My non-friend says that if under chapter, the act, if it's otherwise eligible, then we'll be covered under this also, under the rule automatically. But that's not a question, that's what come to the pleading. What is my pleading? You'll also kindly come to page
Yes.
in fact, what they have done, they have, this issue was when it was raised. In fact, yes, before that, I'll just show you lordship. So far as our appointment was prior to the cut-off date, there is no dispute. But they said that was a temporary appointment. But
The
what they have-
appointment letter you have filed,
Yes.
that is annexed to
Yes,
the
that's
memo,
based on
it says the temporary employee.
Yes.
We
That's
refer
the-
to the application. also.
Other employee, we are coming under the other employee and other employee.
All temporary employees are other employees, according
Other
to you.
employee. Right. That is what. Now you also kindly see
Hmm.
the appointment they made after this act came into force.
That is September, it is December.
Yes, yeah, January. Yes.
No, the 31st December.
31st December.
31st December.
Same. That is same. That is same.
Manager two in the retirement.
That's same, sir. Same. Sir, kindly look to
And
that.
all of them are appointed in the same day or what?
Say
30th October.
different dates, কিন্তু সব cut off date prior to cut off date, there is no dispute over this. I'll show the from the that is
July 81.
Yeah, I got. Sir, এই যে বর্তমান দেখন্তু
Anyway.
30 December 1980 ମୁଁ ଟେ ପଢି ଦଉଛି ଯୋଉଟା ଆପଣ ଦେଇଛନ୍ତି page 1 ରେ for your application dated to April 1980 and to your subsequent interview with us and are pleased to offer you employment as a clerk on a purely temporary basis from 1st January 1981 to 30th June 1981, both get inclusive in our way of so and so. Accordingly, your temporary service will terminate after the close of working hours on 30th June 1981. So this was extended from time to time. The company, however, its absolute discretion may terminate your service. That's
This is continued up till?
Sir?
Continued up till?
Yes, continued. Continued, it was regularized. There is no dispute about that.
Yes.
But you also kindly come to page 31. What now plea they had taken in the
30
counter.
31.
Yes, page 31. Page 31. You also get it. This is on January 30, 1982. After that act came into force.
31.
Yes, sir.
Employment.
Yes, sir. We refer, this is employment after the act came into force, after that cut off date.
Then let us see. First, you have shown me the act.
Again,
Act
section 11,
section 11.
11 subsection was 11 1 and 3.
11
And
1
section
and
that's subsection 3. Then rule 4.
rule देखेले आपण rule 4 देखेले.
Yes, sir.
तापर appointment letter देखेले.
तापर appointment देखिए. Appointment at their appointment before the cut off date.
Letter before
Under the by All India.
before cut off date. देखेले. तापर page 32 of 31 of counter.
Again, I'm
Yes.
just reading it.
Hmm.
We refer to your application dated so and so and to your subsequent interview with us and are pleased to offer you employment as a clerk in grade 2 of the clerical program in our organization with effect from 2nd January 1982. Please note that your temporary employment with us by letter dated 8/7/81 stand terminated after the close of the working hours on 1/1/82. Let's say pause for a moment. Then, though they were continuing under Oil India, their service was terminated, and on the same day they were appointed, and they said that that will continue till 1/1/82. Then, with effect from 2/1/82, you will be on 3 months probation, which may be extended at your discretion. That was the condition, and they continued that there is no dispute over that. Now the next page, your lordship may say, see, this is now they are taking benefit of this in the counter, not in the impugned order.
Next page,
Page
32.
32.
Yes.
You shall not be entitled to any pensionary benefit on retirement.
Hmm.
On retired benefit, if any, will be determined by the company rules as may be applicable.
That is if you continue as a probation. Once you are regular, you have to
That
give
you are-
regular.
That you will also be interpreting. Now, sir, now.
Because this condition which is there for the purpose of the terms of appointment,
Yes. No, sir, that's a statement of-
insofar as temporary appointment is
Yes.
concerned.
60, the impugned order.
60.
60, sir. This is the impugned order.
60 is the impugned order.
Annex 4.
You are agreed by this? Huh?
Yes, sir. This refers to a representation claiming pension under the All India Pension Fund. The matter was considered by the Board of Directors of All India. The board decided that since you are not a member of Burma Oil Company Limited Pension Fund prior to nationalization of Oil India Limited and your appointment to a regular position in Oil India Limited, which you unconditionally accepted, was after nationalization of the company and specifically stated that you would not be entitled to pension benefit on retirement. You are not entitled to pension under the Oil India Pension Fund scheme. Your appeal is being disposed of with approval of the board. No. This is the entire impugned order. Now you are kindly see. I have stated.
It actually says that since in the initial appointment there was a condition that no
Yes, sir.
pension will be given.
That purpose
That
is
will not be given. That's
yeah,
all.
that is what they want to say. Sir, now I have specifically stated, sir, on the Right to Information Act that they themselves have referred to various senior counsels of the Supreme Court and as well as the Guwahati High Court. And that I have, and that I have produced and they have not denied also the counter.
Where is that?
I have given it a memo, so far the personal. That is my entire case.
Memo.
Mr. P.P. Rao, the then senior counsel, they had sought for his opinion.
Where is that?
That is at page 9 of the next memo I filed on 4th June 2023.
9, huh?
That is my entire case, sir.
PP Rao, yes.
Yes. Sir, opinion. I'm just taking to also. The first is the whether issue is this. Whether the temporary VEP employees appointed by All India Limited prior to 14th October 1981 who continued as such and were later appointed against regular vacancy.
Who has sought this opinion?
So the Burma, Oil India, that company had sought for. But
You have opinion from one of the most illustrious senior counsel in this service side, and we used to go and watch him when he argued. You used to take notes.
At least I have occasion to have a discussion conference many times.
My chamber is just his chamber was just behind my chamber.
Yes, sir. Sir, just
Such a illustrious senior counsel.
sir, the opinion is this, sir. Before giving my opinion, it is necessary to refer to the relevant provision of Burma Oil Company Acquisition Share of Oil India Limited and Undertaking of Act, which I have just now read. Next page. Section 11(2) of the Act mandates that every full-time officer or other employee of Oil India who was immediately before the appointed day employed by it shall on and from that day continue to be an officer or other employee of Oil India in that coin on the same terms and conditions, that is in quotation, and with the same right to pension, gratuity, and other matters as are admissible to him immediately before that date, and shall continue to hold such office unless and until under Oil India is duly terminated or until his remuneration and condition of service are duly altered by that company. Then 12(3). Section 12(3) of the Act mandates the curious to ensure that the right and interest of the beneficiaries of the trust referred to in subsection 1 are not in any way prejudiced or diminished. Then Rule 4 of the Burma Oil India Pension Fund Rule, as in force prior to the commencement of the Act, laid down certain conditions for entitling an employee to a normal pension. They are: 1, he must have attained the age of superannuation while in service. 2, he must have rendered 20 years of continuous service in the company. And 3, he should have, at the date of his retirement, been a member of Provident Fund and Insurance Fund India, recognized or Burma Oil India Provident Fund or any other Provident Fund maintained by the company. 4. His membership of such fund should have been continuous for not less than 10 years. And 5. He should have been in receipt of a salary of over rupees 200 per month at the date of his retirement from the service of the company. In the instant case, it is a matter of record that all these conditions are satisfied in as much as all these employees in question had attained the age of superannuation while still in service of the company. All of them had put in 20 years of continuous service or more, notwithstanding the technical gaps now and then, because even during these gaps, they worked actually and they were paid for their works. In any event, such artificial gaps are held to be illegal and arbitrary and violative of Article 14 of the Constitution by the Supreme Court in Ratanlal versus State of Haryana, 85-4 SEC page 43. Therefore, those gaps in any event are liable to be ignored and their service ought to be treated as continuous.
Continuous.
They have also satisfied their condition.
You have not given the full one. Thereafter, there is no.
Oh my God. Scan
Yes.
You have not given the full.
No copy.
File in the writ petition you have filed. No.
Sir, it is here. I have stated all these things, but the opinion I am giving you. Bas. Sorry, brother. That
Yes.
could have been.
Scan the.
Yeah, yes.
Yes.
Continuous.
They have also satisfied. I'm reading from the
Yes,
top.
yes.
They have also satisfied the condition, namely of being a member of the Provident Fund for the requisite period. Admittedly, they were all confirmed employees prior to their respective date of attaining the age of superannuation and were drawing over rupees 200 per month. Therefore, they satisfied all the requirements of pre-existing rules and their right to receive pension on satisfying the three conditions stipulated in the sub-rule 4 is guaranteed by section 11(2) read with 12(3) of the Act. It is well settled that no rule made under the Act can take away or dilute the right conferred by the Act itself. The rule have to be read subject to the Act and in conformity with the provision of the Act. It is also a matter of record that they were never made aware of the requirement of having to make an application in order to get benefit of pension. It is the duty of the employer to bring such requirement to the notice of the employees in good time. The record does not show that the rule were circulated to the employees concerned at any time. There is no mention of this requirement either in the letter of appointment or in the order of confirmation. Therefore, the formality of making an application cannot be impediment in the way of their getting pension. In fact, there was no requirement of making an application under Rule 4 or Burma Oil India Pension Fund Rule at all. For the reasons stated above, I am of the considered opinion that the employees in question are entitled to pension and in all fairness, they may be granted the same forthwith without any further delay. This was given way back in 2011. Now we are in 2025. And the writ application was filed in the year 2017. So now my entire case is this, sir. And I'll give a short note of submission to your sir.
Yes, yes. What do you, how would you get about the opinion which you sought from the senior counsel that states that it face of it?
And not received a copy of that.
Last time they tell
Then you have not copied.
But he has dealt with everything. Under the pre-existing rule of the Burma Oil so and so, Rule 4, they satisfy. The Act protects them under Section 12. And merely because that one word in the temporary appointment, you say that they are not entitled to pension. That was for the temporary employment. Once they are regularized, that condition goes. The Act came into force. Why are you bringing so much technicality?
Only one that's
Yes, yes.
If
If you do one, you give in writing, whatever. You also just give a little note of submission. Argument heard. Give your opinion. Yeah. heard Mr. Buddhadev Rautrai along with Mr. Vishwal, huh? Along with Mr. Vishwal. Subhash is for Oil India Company, Union of India also. And the parties are at liberty to file their written notice. Written देखो जी, दे दिया। ठीक है? Yes. Written note of submission is just give.
By day after tomorrow.
Yes. This matter is pending since 2017.
Yes.
Yes. That time. Is somebody is mentioning? Yes, Mr. Pradhan. Mr. Pradhan, are you mentioning something?
Yes, sir, I'm acting for the Union of India in this.
Sorry?
I'm acting for the Union of India.
You are appearing? Oh, okay, I have entered appearance. Huh? You file your written note of submission. Yes. That's what he said. You give written note of submission. So, but after after 12 o'clock, I'll hear from item 33 onwards. Because these are 91 matter. 35, 92 ready?
I'm ready.
ठीक है.
Last occasion, direct the registry to take the TCR.
Let us see from from 33 onwards. I'll call.
Yes, sir.
Which whoever is ready, we will proceed.
My lord, may I be pardoned to?
Yes,
may-
madam.
My lord, item number 25 and 45, both I do not have any instruction. I do not have any whereabout of the appellant, and I'm not able to even trace out the file.
25.
25 and 45, my lord.
Aged about 60 years and also appellant number 253.
Will you get whereabouts? Huh? Whereabouts and well-being. Huh? 25 days. Whereabout well-being. And 45 also.
My lord.
45.
45, my lord.
What is the age? Just see. 45. 99 matter. Only time give here.
72 and 45 is now 72 years old.
No, the report has come.
Yes.
Report has come.
Now
Their report has come. They are alive. And insofar as your file issue is concerned, you can come and take it in the pen drive.
My lord.
That's the only solution.
I'll do that, my lord.
Don't. That can't be a plea for adjournment. Whereabout we have asked for. Okay.
My lord. My lord.
33 onwards you get it.
I'm going to let up on after lunch.
Are you busy before lunch? At 12:30 you come because 4 matters are I have reserved the judgment. I'll just give dictation and the moment I finish I'll come. Okay.
Thomas. Let's see item 27. I am ready.
12:30. Yes, Mr. Ponda, you are. Which one? 28. 99 matter. 28. 34 ଅଛି ନା 34 is also there. Ramanand Mahapatra.
34
And
PK Panda.
PK Ponda. 91 matter. 34 రికార్డు ఒక లత్న వచ్చి देखो ఎస్ మహాపాత్ర 28 what do you want to do? 99. Small matter, then do it. 2 o'clock? Okay. Yes.
Lordship, item
Then
27.
you come 2 o'clock, 28 at 12:30 will do. Huh? 12:30.
Lordship, item 27 also I am ready, Lordship.
Ms. Ponda will do it. Thereafter, I'll see. ठीक है? Okay. 12:30. Okay. Evidence of C. Loading the cardboard. Yes. Yes, sir.
28. Reserved. The three appellants originally, my lords, appellant 1 is dead. And now the appeal survives so far as appellants 2 and 3 concerned, who have been convicted under section 311 of the SC/ST Prevention of Atrocities Act and sentence of imprisonment for 6 months has been imposed by the trial court.
Yes.
She has also convicted the appellants under 448, 353 and 506 of the IPC, but no separate sentence has been imposed.
Okay.
A very descriptive submission before your lordship is that B1X of the SC and ST Prevention of Atrocities Act punishes intentional insult with intent to humiliate a member of the scheduled caste or scheduled. Now that evidence is lacking here.
Certificate is exhibited.
No, certificate is not exhibited.
Then they have not established. Forget that. Orally saying that I am from.
The two independent witnesses, they don't support it.
Certificate is not there. Then I myself have said in many judgments.
It is not.
It is the expression uses. You have to establish that he is belongs to. Where is the establishment? Merely because somebody says I'm SC or ST will not make him SC ST unless you establish it. That's who is the victim.
Victim is a police constable, PW4.
Two tests you just tell. What is happening in these kind of cases is the victim says that he abused me saying XYZ sentences, and other witnesses says I have seen he is abusing in YZ or like that, and in 313 all these things are incriminating materials are not put. Then that can't be used. This is one principle. Second is in SC/ST case, unless you establish prosecution establish the caste of the victim, to the extent there are judgment which says that the accused caste is also to be proved whether he belongs to general or
not.
And you don't do anything except asking the victim says that I belong to Pano, I belong to bus. Then that's not establishment.
PW5 also supported that yes.
Maybe. Who is the victim?
Victim is PW4.
Let us read PW4 first.
What he said.
and 94, budget to so post under local.
Last paragraph रे कही saying so accused Prakash abused me as so and so, and they also
saying so, Prakash accused
abused me as
धोबा वाली कोई
Aye.
ठीक है entry inside the post and so on so on.
And they gave me threatened that they would assault me and would remove my uniform, that they would tie me.
He was a police constable.
Police constable.
Aye. The incident, he says, happened on 2/7/1994.
Yes, 2/7/1990.
He has lost FIR on 4/7/1990. 2 days delay also is not explained.
Two seven 2/7/19.
Aye. 2/7/94 incident.
FIR on
4/7/94.
4/7/94. Victim. Let us read the full evidence.
Aye. And they also abused us. They entered inside the outpost and obstructed my path. They gave me threatening that they would assault me and would remove my uniform and that they would tie me. Some APR constables were then present in the outpost. They also told us so and so, that has been translated in English, accused Dipti Moi forcibly took away the station diary of the outpost. But I rescued that. I raised shout, hearing which the APR constables and nearby persons came to the outpost. Seeing them, the accused persons went away. I lodged a report before the police officer in writing. Exhibit 1 is my report, 1 by 1 is my signature. I am Dhoba, washerman by caste. As such, I am scheduled caste. Accused persons are Khundayats and Brahmins. So they are non-scheduled caste and non-scheduled tribe persons. Now, he does not say anywhere, my lords, that by using that caste name, he was humiliated.
And moreover, when when he said Duba and all, that
Aye.
time nobody was there.
He doesn't
After
say.
the incident happened, the people came. It is not in front of anyone.
Aye.
PW5.
No.
5 is the
But
only.
Para 6 says that the occurrence took place on 2/7/94. On the very same day, I lost the FIR. It was evening in the lost the FIR on Sunshine. It is
The case diary itself shows me not that it has been registered on 4.
FIR just.
Right.
We
Your lordship may look at the evidence of PW6,
6.
the OIC.
He says that I have given in the same day.
Aye. PW6 says on 4/7/94.
I was attached to Bhograi PS as OIC of police.
On that date by 2 p.m.
We have
I
received the written
this
report from PW4.
The affair registered on 4/7/2019.
But he says the PW4 says that in the same day he is given. Para 6 they see cross examination. Para 6 of cross examination of PW4.
He has himself stated, my lord.
Same day he is given.
On the very day I lost the affair, it was
Evening when I lost the FIR. And 2 lines below that, I cannot exactly say the caste of the accused person. And para 14 he clarifies again, my lord. Inside the police outpost, myself and 3 accused persons were present. Volunteers, others were standing just outside the outpost. କହିଲା ବେଳକୁ କେହି ନଥିଲେ.
And who is the other witness according to you?
PW5 is another
Let us keep
APR.
PW5. What PW5?
Is
I'm
another
constable.
APR.
I was on duty. So session on that date 4 p.m. 4 p.m.
We, some APR constables, were taking rest in a room inside the
We
outpost
found
camp.
the accused.
We found that accused Prakash De, Diptimay Acharya and Sunil Patra had altercation with Constable PW4 in the main room of the outpost. There was a shout. I heard accused Prakash telling PW4 so and so. I found accused Diptimoy snatched the station diary from the table, but while taking away that, PW4 rescued that book. Accused Sunil gave threatenings to kill Constable PW4. Prakash further abused the police officer. When PW4 asked for our help, we rushed to the place. Seeing us and others, the accused persons went away.
Then he only attribute to Prakash.
Aye.
Insofar as those utterances are concerned. Only Prakash.
Aye. But he also doesn't say, my lord, that thereby this PW4 was humiliated thereby. He also does not say that he knows PW4 to be a member of the scheduled caste and being a Dhoba. The entire examination in chief that he knows that PW4 is a member of the scheduled caste kotha se kahun. His entire evidence is that they were in one room. This person is in the main room. And how could he see? He has clarified that in cross-examination third line. By the time we went to the main room of the outpost, PW4 and 3 accused persons were there.
Para 6 of the cross-examination
Aye.
again says,
It is not a fact that I did not state before the IO that accused Prakash abused saying so and so.
is confronted. Yes. PW.
That is confronted to the IO, my lords,
Yes.
PW6.
PW6, let us see.
Cross-examination paragraph 6.
5 or 6?
6.
6, yes.
I had examined PW5. Ananta Parida, PW5 had not specifically stated before me that accused Prakash abused saying so and so, though he told that the accused persons abused saying so and so.
Okay.
He has not stated before me that Diptimay snatched the SD book, not stated specifically that Sunil had given threatenings to kill PW4, though he stated in general that the accused had threatened to kill him.
Then 3 goes.
Aye.
3, 1.
PW2 and 3 are the independent witnesses. They do not support that. PW3 has been declared hostile. PW2 is the other independent witness who knows Maguni Sethi and says that he is Dhobai caste, says that he knows the accused persons. He has given the castes to which the appellants belong. Paragraph 2 rekoila, my house situates near Kamarda police outpost. On 2/7/94 by 10 a.m., a number of persons came in a procession towards the outpost. They gave different slogans and 2 to 4 out of them went inside that outpost. I found them talking with police personnel. I cannot say what happened thereafter. Cross-examination by the defense. ताकू तो यहाँ hostile भी करना है.
Oh.
PW2.
313, let us see.
313. 313 रे प्रकाश रा statement टाकू देखंतु. What is this? 3 questions my lords have been asked. 4 questions. First question is, it transpires from the statement of PW1 Bharata Sethi, PW4 Maguni, and PW5 Ananta that PW4 belongs to scheduled caste of Dhoba subcaste. What do you say? Answer, mu janini. It transpires from their statements that PW4 was attached to Kamarda outpost as a constable under the local limits of so and so. What do you say? Mu janini. It transpires from their statement that on 2/7/94 by 4 p.m., you along with other persons entered the outpost, abused PW4, saying so and so. What do you say? Micha. Then the next question is, it further transpires from their statements that you obstructed PW4's path, gave him threatening that you would assault and tie him and remove his uniform. What do you say? Do you have anything more to say? ସେମାନେ ମିଛରେ କେସ୍ କରିଛନ୍ତି। ଏଇ ଯୋଉ questions ଗୁଡାକ also your lordship will see PW1 ଭରତ ଚନ୍ଦ୍ର ସେଠୀ କୋଉଠି କହିଛି constable ସେଠୀ is ଧୋବା by caste. I do not know the caste of the other accused. କିନ୍ତୁ ସିଏ abuse କରାହେଇଛି ସେଠିକୁ ଧୋବା ବୋଲି ସେଇଟା କହିନି PW1.
Yes.
Abused constable Sethi saying Sola etc. Prakash they abused us. PW2 again, who has not stated anything, he is the only person who has stated that PW4 is Dhova by
No, but PW1 says Diptimoy has abused.
yeah.
And PW5 says Prakash has abused.
Aye.
And they were confronted before police. Who has said? All the accused have said.
Aye.
Inconsistent. Who has abused?
Four ନିଜେ ଆଜ୍ଞା କହୁନି ଧରିକି ମୁଁ ଜାତିରେ
The victim says, victim 4 says
Victim force.
Prakash.
And also corroborated.
Five says Prakash and 1 says Diptimay.
One is independent witness.
He says Diptimay. Accused Diptimay picked up some quarrel and so and so. Accused Diptimay abused constable saying so and so, etc.
One is Habilda.
One is constable. Has to come over police.
That's what. And you have not established on record.
Lordship,
Dhova is a-
Lordship, I can come to page 5 of judgment, my lord. Para 6, Sapara.
Yes.
PW4 is in his evidence has categorically deposed that he is Dhovan by caste and as such.
That's right. He said, but how have you established it?
And seizure list exhibit 3, my lord.
PW4's evidence.
Peruse of exhibit 3 reveals that a caste certificate has been seized showing that PW4
And then
is Dhovan.
why do you say that there is no caste certificate? Certificate is there. PW?
List of exhibits.
Exhibit kind.
Exhibit 3. actually.
Exhibit 3. What is this exhibit 3?
Caesar list.
Caste certificate. Where is that caste certificate? You seized, but that caste certificate is not
That is not mad.
marked.
And another aspect, my lords, is that all these IOs, they are all lower than the rank of Deputy Superintendent.
But this is the incident when that came in 95. That rule 7 has come in 1995. 31st November 1995.
94.
Huh?
Who is at the Jordan?
95 rasla chila. 31st November 1995. That rule came.
But the certificate is not on record and it hasn't been exhibited. And the judgment finding recording.
And moreover, if you have seized the certificate, you should have exhibited. Where is that? That created further doubts.
Page 100.
Where is that?
It is in page 113. The certificate is given.
Exhibited.
Email.
Page 113.
Email so.
That is again seizure list only.
That is
Identified that Sri Samakla Nagar Research of Ambuka is known to me. He belongs to SC, his subcaste is Doda. I will see my success. But it has not been exhibited.
You seized it. If 3 goes, then what remains?
If
Section
go-
3 goes, then what remains?
The very fact, my lords, that the evidence of the independent witnesses does not support these petitioners having entered inside the outpost and committed any offense, everything, my lord, goes.
No, suppose on the ground that,
Other
on the ground
48
that the caste certificate is not proved on record, if
No.
that ground is taken, and if 3 is taken out,
Yes.
what remains?
Nothing else.
448.
448 and 354.
448 also does not cannot apply, my lords, because the independent witnesses don't support it.
Four-
PW2 and PW3 don't say so.
448, 353 and 506 million.
What is the age of these people?
Yes,
40, 29, 33. 3,
The man was 29 years at the time of filing of the appeal in 99. Prakash was 36 years. So he must be 55 now.
1 month, 1 month is given for this 448, 353 and all.
Even that, my submission will be that that offense cannot lie, my lords, in view of the evidence of PW's 2 and 3. The evidence of PW5 cannot be accepted, my lords, because of the fact that he was in a separate room.
Yes.
He could not have seen anything.
And 3 and 4,
Then there is contradiction between the evidence of PW1 and PW4 and 4 with regard to who has abused. The certificate, my lords, has not been marked as an exhibit.
that's right.
So
3,
that
3 is
cannot be
out.
taken into
I'm on that.
The
If 3 is
fact
out,
The fact that these people went inside the police station,
Huh.
that cannot be said to have been established in view of the evidence of PW's 2 and 3. Neither 2 says that he has seen these persons go into the outpost, nor 3 says that he has seen these persons go into the outpost.
I will execute in the 3(1)(x) for SC/ST, and insofar as the other offences are concerned, I grant PO. Balancing act कर देते क्या पाए? Check करो. On the ground that you could not prove the caste certificate, despite seizure you have not, on that ground I'll execute
yes,
3x. And insofar as the other offences are concerned, 1 month sentence is there. I'll grant PO and finish it up. Unnecessary pending. 3(1)(x) acquittal. Arrest. PO. That's the best way of doing it. Unnecessary. Why you selecting? Right. Okay, thank you. Yes. Yes.
My lord, I have a matter today that is a part-third criminal appeal. I want that it may be taken up on 25th or 2nd of December, whichever date is convenient.
Which suits. Let it be included in 25th list. If you see, if it can be possible, let your junior come on that day, or next. Yes. I'll include on 25th. Yes, 25th list. Okay. Have you prepared lease update and everything?
Yes, sir. Yes, sir. Already filed.
And judgment and everything?
Yes, sir.
And the passage which you are relying upon, that also you do?
Already filed.
Yes, sir.
18.
18. Yes.
Yes.
One 47, 123, 149.
147, 148, 307, 325, 323, 341, 506, 149 is IPC. 9 accused persons faced trial. 3 were acquitted. These 6 appellants were found guilty for total under 147 and sentenced for 6 months imprisonment and 323.
And 149.
149.
Yes.
1 year and 5.
147, 323, 147 and 149.
149. 323, 149, 1 year, 1,000 fine. For 147, 6 months.
Then substantive sentence is 1 year.
Yes, sir. 1 year, 1,000 fine.
No, 4 is was by that time 76 years.
By that time.
Ah.
Okay.
By
Yes,
filing
sir.
of this appeal, 2009. So you are maybe
All of them are, the incident relates to.
about 323 agents, he put basing on the medical evidence. He para page 15, judgment of page 15 person para 8. मेडिकल रजिस्टर देखिए मेडिकल रिपोर्ट प्रिपेयर कराई ता ऊपर बेस करके कनेक्शन है
नहीं नहीं आपण are you aiming at a acquittal or what do you want? PO. I think I don't know why should we hear it? PO. Undergone period, can you tell me?
And your lordship, only the 2 accused person, you only know that the surrender on this date, and other 4 are only forwarded. The bail order tam paun se milu bhi nahi, order sheet bhi nahi, kichi nahi.
Have you seen it?
Yes, your lordship. I only seen the only in the final form it is written that these persons are forwarded in this date only. Arrest date, no bail date.
Bail bond and anything like that?
Bail bond,
Have you checked it? Just check it. If you can find something. Proceeding, have you checked the proceeding? Proceeding, just check. Proceeding to भी जोड़ा पड़ियो. Order sheet.
Bail bond के दिन 4-3 दिन में नॉन.
जैसे समझ के कोर्ट को नहीं ले तब पर सेंटेंस सुने ले. 307 होती है ना सर प्रथम तो सेवन जाइए भी ना कि दिन.
That's what you just find out if you can help us.
You also can see the final form. This tells us 22 years.
No, they were arrested, it's all right. When they were
See, that's it.
proceeding is.
Trying a lot to order sheet भी assuming.
When the judgment was passed?
4-3 to the euros.
The trial court gave extended the benefit of 389 also.
Okay.
That is also seen. Incident is 2005.
Yes. Your Lordship, ଖାଲି
Hmm.
ଖାଲି ଗୋଟେ ଚାର୍ଜସିଟ୍ ରେ ଅଛି ଚାର୍ଜସିଟ୍ ଫାଇଲ୍ ଚାର୍ଜସିଟ୍ has been filed 8/2/2008 ସେ ଲାଷ୍ଟ ପାରାରେ ଲେଖିଛି ସେ ଟାଇମ୍ ଭିତରେ ସେ ବେଲ୍ ପାଇଯାଇଛନ୍ତି କିନ୍ତୁ ଏକ୍ସାକ୍ଟ ଡେଟ୍ ଟା ନାହିଁ ସେ ଡେଟ୍ ଟା ବେଲ୍ ପାଇଯାଇଛନ୍ତି ବୋଲି ଲେଖିଛନ୍ତି ଏଟା ଚାର୍ଜସିଟ୍ ରେ ସାର୍ ଦେଖନ୍ତୁ
When arrested, they were arrested.
arrested on 20/12/2007 two persons এটা দেখি Bhagavan sir, petition number, appellant number 1 and 2, they both are surrendered before exam court and they got bail from the court itself on the same day. 3, 4, 5, 6, all are forwarded on 20/12/2007.
Hmm.
Final form there is.
Case diary, there is no indication in the case diary. Accused Chintamani, huh?
Yes, sir.
No, accused Chintamani was arrested before. Because Chintamani 3/5/2006, if you see, order, accused persons Bhagwan Sahu, Chintamani Sahu are produced in custody. And remanded the accused till 12/5/2006. It's very difficult to one after another. I'll give PO then.
Yes, sir.
You take. Take. You. Yes.
Item 27. Yes, sir, I am appearing on behalf of Mahapatra. So the appellant has faced the conviction, faced the offences under section 354 of IPC and section 3 I and HL of scheduled caste and scheduled tribes.
354.
354 and 3 ACS. 3 ACS in the conviction under is 3 ACS. 6 months.
6 months. Road undergone is
15 days.
6 months for
minimum punishment.
Minimum punishment.
what is the period undergone?
15 days.
15 days.
Arrested lordship 10/8/1994 and taken bail granted on 25/8 and 1990.
Because 3(1)(x) is there.
Yes, yes, sir.
So PO can't be granted.
No.
For 354, what is the sentence?
354.
No separate,
No,
no separate conviction is awarded.
Only
Sentence is awarded.
May I submit?
Yes, yes.
The story of the prosecution is that, let's say, PW1, who is the wife of PW3, laws an affair before Soro police station, which was registered on 11 a.m. Lordship of 23/1994. Is that, Lordship? When PW1 went to the appellant house.
No, I'm just trying to find out whether you are convicted under 354.
No, Lordship. Judgment, Lordship.
It is mentioned.
Mentioned, Lordship.
No separate conviction was awarded under offense means what?
No separate.
The guilty of
order for
Sentence I can understand. What is this? I don't know. Whether he's convicted or not.
Hold the accused guilty of offense. No separate.
I hold the accused guilty of the offense.
Offense is
section,
354 is conviction.
Where is that? Which part?
But it is written.
And no separate conviction is
Where?
No.
Judgment page
Judgment
9. Para 12, Lordship.
Para 12.
12, Lordship. In the result, I hold the accused guilty of offense under section 3(1) XI of scheduled caste and scheduled tribes
and the convict
act and convicting thereunder. No separate conviction is awarded for the offense under section 350.
But that is what I want to know. What is this? No separate conviction.
At least they could say 3 months or 6
Where is in the body? Where is that?
No.
Show me that he was found guilty for offense under 354. Show me from the body.
Let's see. Next report also that is after, let's see.
And when you come to the sentence part, nothing is said about that.
About
354.
Eight but 7 pages paper, six judgment or 6
Judgment
Page 6.
internal page 9 of the law.
Para?
Para is also that part of the questions.
Very good.
10 from mid to after from page 9 or digital page 57 or
Para podu na.
10 mid first.
PW1 belongs to scheduled caste scheduled tribe. Para 10.
Yes.
Next one, page 7 is.
From conjunction or between the expression.
Where you are reading?
Page, that is the digital page 57, internal page of the 9 of the judgment law.
Which paragraph you are reading?
10, that is the
10 I understand. You can't pick up some line somewhere and reading. What kind of?
From the first line, you know, her modesty would be liable for punishment. Full stop. From the conjunction or between the expressions dictionary and outrage of modesty, it may be naturally concluded.
1 minute.
If the accused
This
uses criminal.
1 minute. Here, this paper book, there is nothing of that sort. Act provided whoever is coming also belongs to scheduled caste, also from the conjecture it bit in between from conjecture or between the expression dishonor and rousing modesty, it may be natural constitute that if the accused was criminally forced with intent to either outrage the modesty or to dishonor her, the offense is attracted under section so and so. That I know. Where is 354?
In the provision section 3(1) it says that parameter to section 354. That by applying the ratio parameter provision, the learning trial court is come to hold that.
Parametry provision of 354 is made out, therefore section 3 is convicted. Where is 354 conviction?
Specifically 354 is.
That is what I am asking. What is the new thing you are telling?
No, here in the judgment.
Read that.
Yes.
For requirement of 31xi,
yes.
The parameter of 354 has to be satisfied. He says that it is satisfied, therefore I am convicting. But 354 there is no conviction.
No.
That's what I am asking. But he starts with saying that there is a conviction. Read the judgment properly. There is no conviction in so far as 354 is concerned. You have only been convicted under section 31xi. Read 31xi. Read 31xi. What is the requirement? Very good. You don't carry the book. You don't.
I have the book, but it is anonymous.
Right. Incident of which year?
Incident of Lordship, 1994 Lordship.
94. Yes. Read. What is the requirement? XI. XI or XI? XI. Intentionally insult, assault or use force to a woman belonging to a scheduled caste scheduled tribe with intent to dishonor or outrage her modesty. So therefore the parameter prescribed under section 354 IPC requires to be satisfied to bring home the charge under section 31xi. The court says that the parameter is satisfied. Now come to now the evidence. Who is the victim?
Victim is PW1.
PW1.
May I read the statement of PW1? I know the accused standing in the dock. The occurrence took place about 1 year back on Saturday at 8 a.m. My husband was working as a laborer with the accused, and for that the accused was to pay his remuneration. As my husband was ailing, he sent me to the house of accused to bring rice. I told the accused that he used to give us rice by khatta, and by that the real measurement of rice decreases. Therefore, I asked him to give rice with proper measurement. Thereafter, the accused called me inside his house. The accused asked his wife to go to the body side, and accordingly she went away. Then the accused tore my blouse and that used to misbehave, but by escape myself from his clutches forcibly and ran towards body side.
Yes.
That I was running away from the body side towards the front side of the house to go away from the premises. The accused dragged me, catching hold of my hair, and gave me fast blow and
Slap and kick.
kick.
The accused abused.
The accused abused me as then went away home. I narrated the occurrence to my I informed the matter to the
Yes.
PS, and it was reduced into writing by my instruction. He read over and explained the same to me, and I put mine and the torn blouse cloth seized by the police, and those having given me in my Dima, and I took the same. Cross examination practice.
But he doesn't say that she belongs to SC, ST, anything of the sort.
No.
He doesn't say.
No.
Okay. And the cross, has he said anything regarding her caste?
Since 2 to 3 months prior to the date of occurrence, husband was working in the laborer in the house of accused, who was in return laborer. Some money was paid for returning him as laborer, which I don't remember. I was to get labor charges for the working on 10 to 12 occasions, and 3 to 7 days prior to the said visit to the house of accused, my husband did not attend labor work in the house of accused. During the period of illness of my husband, I have taken rice twice. In these 2 occasions, rice was given by the mother of the accused once and by the wife of the accused in the second occasion. I don't remember the days when I took rice on these 2 occasions. My husband...
Doctor has been examined.
No, the medical examination has been denied by the PW1.
Because she says that she received some injury in the left knee joint.
My husband was returned laborer under the father of accused, who used to look after all the affairs. On the date of occurrence, I did not talk.
I was medically examined through the police.
But actually,
she says the accused tore my blouse, sorry, inside the house.
And doctor has not been examined. Lordship, kindly have a glance on PW5 statement, Lordship. First paragraph, Lordship.
But she says that I was examined.
She says, but I wanted to take examine of the victim lady by the medical officer, but she refused to be examined. That is in the statement made by the PW5, Lordship. The cross also.
The accused abused her saying what?
Sali Chamhara. Actually, that wording has not been used initially when the PW1 used to give FIR before did not stated before IO. In the later state, Lordship, there he has not seen any improvement in the evidence.
Where is the FIR? FIR what she says? Just see.
ତାକୁ ଆମ୍ଭେ ଗରିବ ଲୋକ ହୋଇଥିବାରୁ ମୋ ସ୍ୱାମୀ ଶରତଚନ୍ଦ୍ର ପାଣିଗ୍ରାହୀ ତା ସଚନ ସଚ ପାଖରେ ଦୈନିକ ମଜୁରୀ ଲାଗି ଜୀବିକା ନିର୍ବାହ କରୁ। ମୋ ସ୍ୱାମୀ ପ୍ରତ୍ୟେକ ଦିନ ସନ୍ଧ୍ୟାରେ ତାଙ୍କ ଘରେ କାମଧନ୍ଦା କରି ସାରି ମଜୁରୀ ବାବଦକୁ ଚାଉଳ କିମ୍ବା ଟଙ୍କା ଆଣନ୍ତି ଏବଂ ତାଙ୍କ ଉପରେ ଆମର ମଧ୍ୟ କିଛି ମଜୁରୀ ବାକି ରହିଯାଏ। ଗତକାଲି 19/3/1999 ଶନିବାର ସକାଳ 8ଟା ସମୟରେ ମୋ ସ୍ୱାମୀଙ୍କ ଦେହ ବିଶେଷ ଭଲ ନଥିବାରୁ ମୁଁ ତାଙ୍କ ଘରକୁ ବାକି ମଜୁରୀ ଆଣିବାକୁ ଯାଇଥିଲି। ମୁଁ ପହଞ୍ଚି ଶରତ ପାଣିଗ୍ରାହୀଙ୍କୁ
She says Baki Mojuri and
Yes.
there she says that I went for getting rice. Anyway. ମୁଁ ପହଞ୍ଚି
towards rice.
ଶରତ ପାଣିଗ୍ରାହୀଙ୍କୁ କହିଲି ମୋ ସ୍ୱାମୀ ଦେହ ଭଲ ନାହିଁ ତେଣୁ ବାକି
ମଜୁରୀରେ ମୋତେ
ଚାଉଳ କଣ୍ଟାରେ ଚାଉଳରେ ଦିଆଯାଉ। ହଁ
ଓଜନ କରି ଦିଅନ୍ତୁ କାରଣ ତୁମେ ଚାଉଳ ଦଉଥିବାରୁ ଓଜନରେ କମ ହଉଛି। ଏ ବିଷୟରେ ସେ ରାଜି ଦେଇ ମୋତେ ଚାଉଳ ଦେବ ବୋଲି କହି ଘର ଭିତରକୁ ଡାକି ନେଲା ଏବଂ ତାଙ୍କ ସ୍ତ୍ରୀଙ୍କୁ କହିଲା ତମେ ଘରୁ ବାହାରି ଯାଅ। ମୁଁ ମଧ୍ୟଭାଗକୁ ଗଲା ପରେ ହଠାତ୍ ତାଙ୍କ ଘରର ସଦର ଦରଜାକୁ ବନ୍ଦ କରିଦେଇ ମୋତେ ମୁଁ ପିନ୍ଧିଥିବା ଛିଣ୍ଡାଇ ପକାଇଲେ ଏବଂ
outraise her modesty. See, modesty is outrage because PW1 has to be believed, and the way you have dealt the blow and torn the sari and whatever you have done. So therefore, that part is also satisfied. So the all the requirements of 3xi is satisfied. Tell me.
Lordship, during the time of giving statement before IO, he is not
Contradiction here and there, small contradictions are neither here nor there. I've seen the contradiction also. Contradictions are also not very. The FIR, she says, very detailed, she says, he went to collect his wife, her wife, husband was unwell, therefore she went to collect the wages, and all these things are straight away corroborating with the evidence.
Lordship, she is sustained injury, Lordship.
Hmm?
Then he could go for a medical exam.
You have not been convicted because of injury. Had there been injury 323, that is not the offense. Offense is 31x. Just concentrate on 354. 354 ingredient, 31x ingredient are same. Assaulting or dealing with a women belongs to SC/ST in order to outrage the modesty is the requirement. All the ingredients are fulfilled on the basis of the evidence. Now you tell me.
May pray for another date, Lordship, I will prepare from this. 350.
PO can't be given.
No.
Section 19. PO can't be given. Then what is the way out?
354 is there.
What is the way out? Therefore, I asked whether 354 is there or not. It's a case for it has to be
354 part is
conviction has to sustain.
Does he pray for another date, Lordship?
Thursday.
Yes, sir.
Thursday, parted Thursday. Yes. 96 matter Thursday. Yes. If you can get some judgment and something, otherwise, first item. Indicate the first item. First item on Thursday. First item, no adjournment will be given.
No,
Parted. Otherwise, I will dispose it up like that. Get some judgment, prepare if you can.
I will say one judgment I have that doesn't lead to lots of.
Don't do half-heartedly because the evidence is telltale against you.
Yes.
Don't do half-heartedly. Since you have taken time, put some efforts, find out some point. Okay. On this point. Yes. Yes. Next. Any other medical?
ନାଇଁ ଗୋଟେ 17 ଟା ଗୋଟେ ଛୋଟିଆ ମ୍ୟାଟରଟା ଅଛି
କଣଟା?
ସେ 17 ରେ 324 ଆଉ 34 ରେ 3 months conviction here also. 3 months of conviction. 324 and 34.
Okay.
Item 17.
Yes. Yes. 320.
Page 7 yours. Page 7 of the judgment.
324.
324 and 34. Acquitted from 307 and 3 of SCST.
So 324 conviction.
324 conviction.
Conviction,
3 months. Yes, sir.
3 months.
3 months.
Show me the victim.
1 to 4, which is they didn't cross-examine anything. People 1 to 4. Can you see people 1?
Then this evidence has to be expunged.
Yes, sir.
That can't be relied upon at all.
And PW 5.
No, let us see.
Yes, sir.
Let's see. Who is the victim? Who is the victim? Declined. Declined. It's not a take. Cross examination is decline.
Cross exam decline.
Decline is something different. Decline. Who is the victim?
Yes, sir.
Injury is two injuries. Incise wound.
Pedal 6 is the doctor. Pedal 5 is the doctor.
Sharp cutting object and injury number 2 might have also caused sharp cutting. The doctor doesn't say that it is a
Yes, sir.
injury report is what is the injury report? Exhibit 1. Exhibit 1. Exhibit 1. A simple injury.
Simple injury, yes.
What has he used? Who is victim? You say small matter, you. I said, I know both the accused persons to talk about 4 years back. Good morning, the persons. Also,
You should pedal 1, can you say pedal 1 and also? When I was returning after my accused owner dealt a blow.
PW1 is the injured.
Yes, sir.
PW1, read it, PW1.
Assaulted on me, the right thigh, and accused Krishna, forcefully there, force a broken bar right.
No, who has given the? I was returning after injuring myself. Accused Kunda dealt a blow by means of a iron rod, assaulted on my right thigh, and accused Krishna poked with a great force.
With force, a broken bar,
Then
bar right,
bar light.
below on my left shoulder, onto the left side of my chest near the armpit.
So one is right thigh, another is left side of the chest.
Yes, sir.
Bled profusely and become
And become
went to
the Krishna.
then Krishna and
Then many villagers gathered near my flat.
no, Krishna and Honda.
Krishna and Honda. Both have the appellant in this case.
Honda, okay. They have not cross-examined.
Pedal 5 is the doctor.
This side nobody is there. Nobody is sitting.
Yes. Nobody.
Everybody is gone.
No, like, I'm going to
That is why I was searching someone. They will call someone. When they require, they are not there. See, last time also none has appeared.
Yes, sir.
And cross-examination kornanti. Control 324 hour. Iron rod you have used. Injuries are simple, no problem. But this is then what to do? 324 you can't escape the liability from the return.
Pedal 5 also saying that in the injury.
C5 has left side anterior aspect.
Forearm. Cutting object and might have also been possible to start cutting open. Injury one is possible by striking different dark light. And even PW 1 saying that the barlight was used.
What are you saying?
তার প্রমাণ বলে না তা
70
অ্যাডভোকেট কে দেখুন
70 number item set.
অ্যাডভোকেট কে দেখি
It is 70 number item.
IO is a PW5, huh? 96. नहीं है इसमें कुछ नहीं कर सकते. Okay, right off. 2 convicts, Purushothandra Biswal and Hon'Ble, jointly filed the present appeal, challenging the judgment and order dated 24/10/2010, passed by the second additional sessions as Cuttack in ST case number 350 of 01, convicting the appellants for offense under section 324/34 IPC, and on that count, sentencing them to undergo RI for 3 months, subject to setting up the period already undergone under section 428 CRPC. The appeal is pending since 2008. When the matter was taken up for hearing, none had been appearing. Even today, when the matter was taken up, none have been appearing. Therefore, what is your name?
PK Malik Lordship.
PK Malik.
PK Malik. Pritam Kumar.
Mr. PK Malik, who advocate who is present in the court, is requested to assist the court in capacity of evacuation or paragraph. Take prosecution story is the appellants initially stood charge for the alleged commission of offense under section 324/307 IPC read with section 31X of HCSTPO Act. However, the trial court PO Act, the witnesses, the prosecution examined from witnesses. The trial court, after analyzing the evidence, why ACST Act is there is no discussion of ACST? Huh?
No. The certificate was, is the certificate regarding to the.
Certificate?
The class certificate.
Exhibit 2 there.
Is there.
Exhibit 2.
Exhibit 2 is the class certificate.
However, the trial court finding that the investigation of the offense was not carried out as required under section 7 of rule 7 of ACST prevention rule 1995, recorded as an acquittal in favor of the appellant insofar as offence under section 3 of so act is concerned, as being the investigation initiated. The reasonings are recorded in para 5 of the judgment, which reads as under. By relying upon the prosecution evidence, the trial court also arrived at a conclusion that this is not a case under section 307 IPC, as there is as the prosecution failed to bring on bring home the charge of intention of the appellant to cause bodily commit murder, intention to commit murder. The reasoning of the trial court is reflecting in paragraph 8. Paragraph 8.
You also can paragraph 5 regarding the SC/ST also.
Paragraph 8. Eventually, the trial court in paragraph 9 has recorded that the appellants are found guilty for offence under section 324 oblique 34 as 30, which the relevant paragraph is reproduced as heading. In this case, the defense has declined to cross-examine all the witnesses, all the prosecution witnesses, except cross-examining PW6, who is the IO of the case. PW1 is the victim in the present case, who in his testimony has stated that the incident had taken place 4 years back at 5:30 a.m. when he was returning after being eased out. Accused appellant number 2 dealt a blow by means of a iron rod, assaulting him on his right thigh, whereas accused Krishna Chandra, whereas appellant number 1 poked with a great force a broken bar light below the left shoulder to the left side of his chest, left side of the chest, near the armpit. He bled profusely and became unconscious, and he was taken to Mohana PSC for treatment at about 7 p.m. Police came to the hospital, recorded his statement. This witness, the defense declined to cross-examine this witness. His testimony is directly found corroborated with the testimony of PW4. PW4, na? Witness?
5 is Dr. Lewis.
No. Who has seen? PW4, who is the brother of PW1. PW4, in his deposition, PW4 deposed that he is not seen. He was told. He told, deposed that the entire incident has been narrated to him by PW1 and PW1. he went to the hospital to see his elder brother, and the incident was reported to police. Even this witness was not cross-examined by the defense. Who is the witness, eyewitness?
You also can see people 3. Here he says that I came out from my house having heard a loud noise and saw the accused persons were running. That means the
PW3,
Yes, sir.
who is an independent witness, he stated that when the commotion, when he heard the commotion, he came out from the house and saw that the accused persons were running away.
I found people were
And running away. He further stated that he found PW1 was bleeding profusely from his left side chest and had some broken glass pieces were lying on the road. People gathered, he stated that people gathered there and told that the accused persons had fled away after assaulting PW1. This witness was also not cross-examined. The evidence of PW1, 3 and 4 stood directly corroborated with the evidence of PW5, who is the doctor who examined PW1. The doctor in his testimony has stated as under Dr. The medical examination report is exhibited as Exhibit 1. Perusal of the Exhibit 1 indicates that the statement, evidence indicates that the two injury found on the person of PW1 are simple in nature. The conjoint reading nature. PW6 is the investigating officer. He deposed. He deposed as under. He deposed as under for the Purata Kurdi, the paragraph. Cross exam. The prosecution, the defense, even reluctantly appears to have reluctantly cross-examined the said witness. Conjoint reading of all the evidence together, the only inevitable conclusion that could lead to the conclusion that both the accused number 1 by using an iron rod assaulted PW1 and accused number 2 assaulted iron rod and appellant number 2. Appellant number 1 used a tube light to stab the PW1. That part of the evidence stood corroborated with the evidence of PW3, 4 and 5. Therefore, there is no reason why the conclusion drawn by the trial court, which is reflecting in the paragraph 9 of the judgment, which has been reproduced herein above, shall not be affirmed. There is no doubt that the injuries are simple in nature, but since the appellants have used IPC 324.
324
What 324?
Which may extend to 3 years?
No.
Or which may both?
Since appellant voluntarily caused the hurt by a dangerous weapon like iron rod and
Broken bar light.
tube light, they can't escape from the liability of offense under section 324 public 34 IPC. 34 IPC. Accordingly, the trial court judgment is upheld. Upheld. Insofar as at this stage, let an amicus curiae submits that the incident relates back to over here,
2008.
2008. At that point in time, the appellant number 1 was 37 years of age and appellant number 2 was 25 years.
25.
Base number of years at so therefore lenient would be taken. I'll just keep PO review taken. The trial court has awarded a sentence for 3 months RI. 3 months RI for the offense under section 328 CRPC. PO. ठीक है PO ठीक है dispute ठीक है anything? Thank you.